Hey, so this is about what you do as a pro se when you have filed for an ALJ hearing, and there you are. You filed for your hearing. Now you're twiddling your thumbs, right? I'm going to explain what I think you should be doing, okay? And the reason I bring this up is because I get too many contacts of people who want a representative, right? And when I ask them, so where are you at? What have you sent in? Da, da, da. And they are deer in the headlights, literally. Like here they have been self-representing for quite some time since initial recon. And by and large, I find out that they filled out the application and then on initial, and they did the function report and the work history report to the best of their ability. And then they did nothing. They got a denial. They filled out the appeal, say online, with one or more medical providers, hopefully. And then they did nothing. And then they got a denial. And then they received their denial on recon, and they did their appeal for the ALJ hearing. And then they get the letter from the ALJ saying, we received your appeal, and they're acknowledging it. They might then send you, it might be with that or separately, information about how they're doing MS Teams hearings now. And would you like to agree to do that? Or, will you insist on an in-person hearing where you have to drive here, or, phone hearing, that whole thing. Then they will send you, if they're doing things properly, a letter saying, okay, now we've exhibited your file. Make sure you get us in all this evidence that we don't already have. So what do you do? Do you send in evidence? Do you not? Like, what have you been doing? So here's what I would do. Even if you've screwed up on initial and recon and you lost on those levels, and you maybe didn't send things in, or, what have you. This is your time. You have, from the time you get, when you first appeal, you can literally have 3-4 months, depending on how fast the OHO is going, Office of Hearings Operations, until you're scheduled. That goes really fast. Aside from the fact that you should be treating, I can't say it more, treating for all of your big and small impairments. We have a video on that. I'll stick it on the end. You need to be ordering your medical records from your provider, filling out their HIPAA form, or if you're money conscious, using a high-tech HIPAA form so that they email you the records or they fax you the records, so that you don't have to pay the paper and stamp and ink fee of $1 a page for 7,000 pages, because that sometimes prevents people from getting the records. But in any event, you are the claimant. It is your burden. As much as the ALJ will probably, and I think is supposed to help you, the ultimate burden is on you to follow all the rules and present your evidence. So you need to, I wouldn't rely on the hearing office, who's very busy, probably understaffed, to get it all done for me, not with something so important as this. So if I were you, I would be I'd be looking at my application. What doctors did I give? I would be looking at my recon appeal. What doctors did I give in terms of what I'd done since I applied? And then I'd look at my ALJ appeal, which is supposed to be the doctors that you've seen since you filled out the recon appeal. And you need to get a copy of your entire exhibit folder. So you need to contact the Office of Hearings Operations. Their number is in the top right corner of every letter they send you. And you have to ask for a copy of your file. Historically, they've sent it to you on CD. How many of you don't have a CD reader? How many times did the CDs not work? How many times, if you do have a CD reader, it doesn't work? So I would suggest you tell them, I don't have access to be able to read a CD, if that's the case, and ask them to email you the file. They can do it. They've done it before. So if they tell you they can't, they're not exactly being forthright. They could also potentially upload it to your ssa.gov My Account online access. So whichever way works, you need to look at that file and you need to see that everything that's in there. You're going to want to go to something called a detailed earnings report and see if your earnings from the time you were 2 and taking out the trash, kidding, but whatever you reported to the IRS year after year from the time when you were young, you want to go through and see if you recognize what happened all the way through all the years, particularly the last 15 years, because that is what is considered present day 2023 to be the relevant work period that they're going to have to consider when they decide whether you're disabled from doing those jobs. Okay. So you want to go through and make sure you can identify everything in the list. They give an address, but it can be confusing, guys, because the corporate name under which taxes were filed for you may not be the same as the little store you worked at. It could be owned by a bigger corporation or whatever. So you're going to want to take time to go through that. It's going to go through every job of reported income, or if you had self-employment income and filed your own tax returns, or potentially, I think if there was a 1099 issued, you were self-employed, got a 1099 from a client, and whether or not you filed taxes, you might see that up there. I'm not sure, but the point is you want to be able to identify all that, because when the judge asks you at hearing about each and every job on there, because he needs to know, and the vocational expert that's going to categorize your past help at the hearing needs to know your past work experience. You don't want to be wasting time trying to explain and figure it out. No, I'm not sure, Judge. Because you have very limited time to testify at your hearing. And you do not want to be wasting time about stuff that, if you had a representative such as myself, I actually make sure we have that all done in advance. If I wasn't around to work with the person on their work history and make sure it was complete, I actually work with them to submit a new one and say, this is a corrected one that has all the relevant information that they didn't put in, which is very typical. But it's really, really important. And then, and this, at my last hearing, this happened, the judge was about to go into work history. And I said, Judge, I just want to let you know, we submitted an updated work history report in August, because the one submitted by the claimant when she was pro se was really, really not covering all the bases. And next thing you know, we didn't have to waste any of the 20 minutes or so that you might have to testify, spending almost all of them on work history. Didn't have to do it. Okay, so that's one thing. That's probably, I want to say that's in the D section, but don't hold me to it. But it is called detailed earnings. So that's one thing you want to do. You want to go through your F section. That is all your medical records in exhibits, exhibit 1, F2, F3, F4, F5, F6, F. And you want to, if it's me, you're going to itemize every date of treatment in each exhibit. Make yourself, a document. I call it like a chronology. Well, it's not really a chronology. It's an exhibit list with the details of each exhibit in there. So if you see that there's 3 exhibits with Dr. Jones, who you see all the time, but you see that it's lacking the last 6 months of those visits, because maybe you didn't tell the SSA you had 6 months more of visits after you appealed for recon. That stuff's not going to be in there. So you are going to want to order those records. Now, the ALJ will probably ask you for updated medical information on a little dandy form they have. And you will want to fill that out and get it back to him so that he will help. But if, in my opinion, I think, you really got to try to help yourself here. Okay. Not to mention, you want to know, if you get Dr. Jones records and then you shoot them up to the ALJ, that Dr. Jones office sent you the complete set and didn't leave anything important out. So I would literally go through and find out all the exhibits, what's in them, and figure out what's missing. Rarely is there something not missing. And you need every crumb because remember, you were denied twice already, so this is not the time to be slacky. So you're going to want to contact each office and send them a HIPAA form. Again, they probably have their own HIPAA forms. They would be very happy for you to send. With my clients, they execute a high-tech HIPAA form that is where they are asking for their records. We help them facilitate getting it to them. And then we have access to where they're asking it to be sent, even though it's to the patient. And that's how we help them get the records and get them into the ALJ. It can take sending a provider multiple requests. They have a 30-day time limit under HIPAA. They usually don't follow it. HIPAA has very little bite. So you want to get on top of this. This is something that I would even say when you get your recon denial, maybe don't appeal it in the first month. You have 60 days, right? Maybe do it after that because you need to use as much time as you can get. So why waste the month there that it'll be an extra month you buy that you have to start doing this? Because you can ask for the file from the SSA as well. They're supposed to be able to email you the file or stick it up to your SSA.gov area. So hold on one second. I have to go and chastise a critter. I'll be right back.